Welcome to Redirect Immigration Law and Perspectives. My name is Stephen Robbins. I'm here with my co-host Matthew Archambault, and this week
that's true.
There he is, and here I am, and we're joined by, I don't know if we can call you friend of the show. You've been on the show before. Are you a friend of the show?
I think we're friends. I mean, we should check in after this conversation, but I think we can say we're friends.
Friends is that's a Facebook designation, and
that's true.
As far as I know, we're just followers. We're followers of each other.
Yeah, we're taking it slow. Right.
There you go. Okay. Michael Kagan from UNLV, University of Las Vegas, right?
Nevada, Las Vegas. Right. Yep.
Running Rebels.
Wait, are you guys still the Running Rebels?
Is that... We're not. No, we're not. No, yeah. So the Rebels and the icon has an uncomfortable resemblance and probable origin to a Confederate general. Not a specific federal general, a cartoon Confederate general that some people at one point a few decades ago thought was funny. It's a contentious issue around here, but the university got rid of it, removed the Hey Reb statue. It was gone in the middle of the night. So we're just UNLV now.
Well, what's the mascot?
Yeah, what's the mascot?
You know, I'm not sure we have one. I don't think we have a mascot. But I'm probably going to get canceled on campus now for not knowing this. I still follow... I went to Northwestern. I'm following Northwestern Wildcats. Ask me about that in the NCAA tournament.
That's boring.
Yeah.
So in my hometown, there was the South Albany High School. They were also the Rebels. And I'm pretty sure their cartoon, general was literally from the Confederacy. Like the flag and everything. And they also replaced it. So.
Yeah. Well, the thing here is Nevada was the part of the state that used to be populated most was the North. Now the South, where Las Vegas is, has most of the population. But when UNLV was started in the 50s, the South was like rebelling against the North. You get it? Rebelling against the North, right? People just thought that was funny, casual Confederate humor because the Civil War was not remotely serious.
I think it was... Right. I think they were probably also racist and identified with the Confederacy on some level. I'm guessing. But
yeah, I don't know. Maybe they used to call this place the Mississippi of the West. I don't know if that had anything to do with it. Oh, probably coincidence. Probably. That's now Idaho, I feel like. But anyways, now, Matthew, you wanted to have Michael on. And
yeah, because you have a draft of a law review article that you put on Twitter, and I think it will be final next year, right? And we kind of we love reading law review articles. That's just what me and Stephen do. Like all that, we message back and forth about various law review articles.
Right.
This one actually seems interesting as opposed to the other thousands that we have read.
Right. I think there's a compliment in there somewhere. So thank you. Yes.
So this is something I've been kind of beating the drum about on this show, on Twitter, my ALA listservs, about not just conceding charges in immigration court, just kind of giving up in immigration court in the pleadings phase and really holding the government to the burden. So I have to say during the past couple of years at Masters, now listening on WebEx and all that, where I would hear all the attorneys go before me as I wait. And it's really made an impact. I think I've heard contested charges on maybe 2% of the cases I've listened to. So why don't you explain to us, what is your article about? It's called Mass Surrender in Immigration Court, and it's going to be published in UC Irvine, right?
Yes, next year. And it's on, but you can read it now in its draft form on SSRN, where fine law review articles are found. So I think maybe back up before we start talking about pleadings and what my article is about. I think there's something else here that looks behind the surface that has long bothered me and might have bothered you too, which is that what we call removal proceeding, a deportation proceeding, has got two parts. But most of the attention has usually been sucked up by the second part, which is when immigration lawyers and judges call claiming relief. And that's when you apply for asylum, for instance. So there's tons of discussion, as there should be, about asylum law and asylum cases. And that's done at that second part. There's other things that go in there too, right? I don't want to go into the weeds. You all know that. But the first part, though, is when the immigration court is supposed to find out whether this person who's in front of them, the respondent, is actually deportable from the United States, because if you're not, you don't need to be there claiming asylum. There's other ways to claim asylum anyway. And we don't want the government to be able to just deport people without some neutral adjudicator finding out, yeah, this is the type of person we should generally deport, the same way we wouldn't want the police throwing people in prison if they're innocent. I'm sure that would never happen in this country, right? But it turns out it does happen. And, there's even the General Accounting Office has found that, U.S. deports U.S. citizens, which is sort of like the equivalent of innocents on death row for immigration land. So it's this first stage I wanted to pay a lot more attention to. And I think I also collected some data from our court here in Las Vegas. And I sent a research assistant to observe for 2 months and basically found that 95% of people, when they're at that stage, they don't make the government bear any burden of proof at all. They just admit and concede the charges. Admit and concede is even a phrase.
So when an individual is put into immigration court proceedings, we now call them removal proceedings, the government generally has the burden of proving that the person is not a U.S. citizen, does not have proper legal status here, and can be removed from the United States. And the first part is called respondent. Typically, the immigrant would go in front of an immigration judge. And one immigration judge's duty is it's in the regulations, it says the immigration judge shall read and explain in a language that's clearly understandable for the person in front of them what the charges are, why they're there, and how the proceedings are going to go. And generally speaking, when a represented client is in front of a judge will say, Mr. Robbins, do you waive readings of your client's rights and explanation of the notice to appear? And we all say, yeah, because do we all want to sit there for 20 minutes while the judge reads this thing? No, we really don't. Okay. And then the judge will ask, how do you plead? And mostly, as Professor Kagan is saying here, people will say, yeah, we admit the allegations, which are usually you're not a U.S. citizen, you're a citizen of some other country. You entered the United States at an unknown place and at an unknown time, and you were not admitted and inspected. That's generally the four most common ones. And generally people say, yeah, we admit those. And then you say you're removable under this section of law. And then we'll say, yeah, we concede removability. And then we'll go on. But in reality, the government actually is supposed to be proven this first part. So my general practice is that we deny charges and we don't concede removability. And there are a lot of reasons why we do this. One of the main reasons is really just kind of being to the government and make them do something.
Don't say that on the podcast.
It's just like do something because so Professor Kagan, tell us how difficult it is for the government to prove their burden, to uphold their burden.
It's assumed that you're an you don't need to spell it out.
Okay, well, good point. Good.
Yeah, and that's not exactly the way I'd phrase my reason, but I do the same thing. So the answer though is it is not difficult at all for the government to prove its burden because the government, one of the problems that an immigrant faces facing deportation is the government gets to make the rules of the game, and then they also get to be basically prosecutor and judge. And they, over the last few decades, the government has eroded the burden of proof. So really all they have to prove actually is foreign birth.
Right.
And the way that'll be done, especially if someone doesn't have a lawyer, the immigration judge won't even take formal pleadings. Like a lot of us know, from watching Law and Order, you've been charged. Did you shoot the sheriff? And you get to say, not guilty. I shot the deputy. You probably shouldn't say that. Your lawyer should punch you if you speak anymore. But in immigration court, the immigration judges often do that really casually with unrepresented people. They'll just sort of say, so, sir, where were you born? And the people, want to be cooperative. And that seems like a casual question. And they'll say, I was born in Mexico, or I was born in the Czech Republic. And they don't realize that they're being asked to take a legal position, not just give facts at that stage. And they've basically just confessed. And they have actually a right to remain silent, which immigration judges, I have never heard an immigration judge tell someone, you don't have to answer my question, and it might be in your interest not to. Never heard an immigration judge do that. But of course, even with lawyers, we found 88% Lawyers do exactly the same thing. They just admit and concede for their clients. And that I really would like that to change, just like you said.
I wanted to share a story from a colleague who recently they were asked to provide written pleadings, which is basically just this whole process, but in writing. And so he denied the allegations. And then the government, the ICE attorney, missed their call-up date to establish removability and then filed something late without a motion for untimely filing and put in there, they attached the I-213. Now, this is sort of the document that contains all the ICE information about the person, where they encountered them, what they know about them. Sometimes it includes documents that are attached. So they filed this I-213, and they say in their response, in other words, it appears that the respondent, through counsel, is simply trying to cause the court and DHS to expend additional resources for the mere sake of doing so. Now, it turns out that the NTA actually, in this case, alleges 2 countries of origin. And so, not the NTA, but the I-213. So the evidence that they filed to establish removability and country of origin actually doesn't do that. And so I think for practitioners, it's a good idea to not just, maybe consider your pleadings, but then to also actually read the I-213 and see what it says, because it might be, like in this case, unclear. But if you could respond to this ICE attorney who says, look, that's all well and fine, right? You can deny the allegations, but really what you're doing is what Matthew said earlier, which is being an and trying to cause delay.
Yeah, I'm not trying to cause delay. And actually, given how low the burden of proof is, if the government has its act together, the amount of delay this causes might only be a few minutes. But the government doesn't always have its act together. And the fundamental issue is that the government is trying to take someone's liberty away. They are trying, obviously, our clients are often detained. And even if they're not detained, the whole point of the proceeding is the government is going to use its force, use violence, if necessary, to take someone out of the country to a place they don't want to go. That is the whole point of these proceedings. It's a huge deprivation of liberty, and the government ought to be put through its paces. And there are some tactical reasons. Matt already alluded to it, why I think it's advantageous. But part of the reason I think we ought, as a default, unless there's a good reason to do otherwise, to be denying charges is it's a way of communicating the seriousness of what we're doing, which so much of the process and the people involved do everything possible to minimize. So we've been yelled at by immigration judges and DHS attorneys. I have to prep students to be yelled at because it's such a gasp, wait, did he just deny charges moment, right? And it should not be like that. When the government is trying to force someone out of the country, to require them to put forward a hearsay government report that they're supposed to have in their file anyway, and that usually is enough to meet their burden, that ought not to be too much to ask. And it says a lot that it's considered such a shock to even demand that.
So when we bring up this conversation with other immigration attorneys, one of the first things I'll hear is there are good reasons to admit and concede. You can't just do it on every case like carte blanche. I hear this all the time, and then I just sit back and think but you on every case carte blanche admit and concede.
Exactly.
So there are times where you might want to admit and concede. It might be advantageous to your client. Maybe your client's detained and you're really trying to push along proceedings. Maybe your client had filed an affirmative asylum application, which on its face, that's been referred to the court, will be used for those charges. And you just kind of want to get through proceedings. But for the most part, I would probably say 90% of the time, you should really hold the government to the burden. One, I think, Professor Kagan, you probably say better than I do, kind of make them do the job because, these are important proceedings. But also, you get this I-213, this government document that can be riddled with errors, but also can provide you with, really good information about your client. At the border, did they request asylum? Do they have it reported that your client said they didn't have a fear of going back? Do they have criminal charges there that your client might not have told you about? Or that could also be erroneous as well, and you want to be able to clear that up. So there are a lot of good reasons, And it's funny because that's the main reason I do it. It's not really to be difficult. It's to get this document. And lots of times before the hearing, I'll say, listen, I really just want the I-213, right? Can you send it to me? And there are some government attorneys who will send it over. But there are others who say, no, we can't provide you that document. It's like, right. So the government wants to have it both ways. Lots of times they kind of want to hide the ball on you. And then they get upset when you tell them, do something that's going to make them produce that ball. And that ball, the I-213, is the reason why your client is in court. So you should have it. I mean, it should be, the I-213 should be filed with the NTA. I don't know why don't. It's kind of similar to like an indictment in criminal court. The prosecutor just doesn't file like one-page document saying so-and-so robbed the 7-Eleven, and that's it. Like the indictment includes other factors. So I don't know why they don't, but if you're proceeding with the case without the I-213, you're probably committing malpractice.
I totally agree with that. Let me actually say, because I think what the main pushback I've heard, I agree with you, first of all, that there should be no default either way, but the default should be flipped. I should not be conceding a right for my client, even if the government would easily overcome it. I should never be conceding a right for my client without a concrete reason, right? And there is sometimes a concrete reason. Maybe it's the timeline, we don't want the case to be delayed another 2 weeks, or I don't know, or maybe the government has actually offered me something. We don't have a lot of direct real plea bargaining, but if the government's actually giving me a concrete advantage, I'm willing to do this. I'm not against. I wish we actually had more of that kind of negotiation. What I'm very against, and I think actually the strongest pushback I've got on this issue, is it'll make the immigration judge angry. It'll make DHS angry. And that is true. Like I said, we've been yelled at by DHS attorneys and by immigration judges, actually not by the ones we have in Vegas now, but some that we've had in the past for denying charges. And I don't think it's crazy that lawyers fear that, if you get yelled at by the judge, it's going to hurt your client somehow. But I also think it's something that lawyers also have to be really skeptical of, too, because this is not like a civil area of law that usually settles by negotiation, first of all. And I've never seen any evidence that this type of thing really changes the decision. In fact, I think there's reason to think that making it more serious might help. And for all the reasons you mentioned, even if I don't defeat the charges, just knowing what the government has is a tactical advantage going forward. I also think lawyers got to be cautious because we're all social animals and we want to be part of the club. And you can be made to feel like, whoa, you don't know how the game is played around here. You violated the unwritten rules of the club, even though, the court's manual says you can deny charges. You really can't. I can't believe you do that. And I think lawyers who are repeat players in the system need to be really cautious about doing things that compromise their clients' rights because it's become the norm of the court. And it might be our job as defense lawyers, which I think is what we are in this court, to push back against norms that are really unfavorable for our clients.
Right. I think it's important to note the burden is on the government. Like, it's not us trying to be rude. It's like, it's the statute, it's the regulations. This is the way the law is designed. And like Matthew was saying, an analogy would be like, if the police came to you and said, would you give us the probable cause that we need? We think that you were driving under the influence, but it would be helpful for us if you just signed this probable cause waiver. Or if, like he was saying, if they filed we think this guy did a theft, and you went to court and said, can we see the indictment? We just want to see the indictment.
Yeah.
And the judge and the prosecutor were, I've got to download it. And I'm going to have to print it. And, what the I mean, come on. Why are you not just playing ball? Like, why don't you admit you did the thing? And that's sort of what we are faced with. So the anger and the outrage is really strange. And I think it's a product of the cultural practice of, that we've all been a part of like, you go along to get along, and you just sort of go through the motions.
Well, here's a practice pointer. When you have a master hearing, these preliminary hearings coming up, you can simply find out who the trial attorney is going to be, send them an email a day or two beforehand, and say, here's the case I'm on. I'm going to be denying charges. Maybe if you want to file the I-213 or send it over to me beforehand. Just give them a heads up, because in one way you understand, right? They have like 60 cases in the docket that they're going through. And they're trying to get through all these cases, and having to stop and file this document is, as it shouldn't take that much time, but they're doing a lot. So I try to do it the best I can beforehand and get that document. And then I'm not like just surprising them. And I find that to be a very effective way of communicating, being cordial, saying, hey, this isn't really personal. I'm really not trying to be an asshole, as I was kind of jesting before. But, I do, even that, sometimes I'll get pushback from the government. Like I said, they'll be like, well, we can't, I'm not going to give you that, and this. But it's, I think it's helpful. And a judge that is going to yell at you for this is probably not going to be a judge that you're going to win in front of anyways. Let's just be.
The judges that used to yell at my students and me for denying charges had 95% asylum denial rates, right? So we knew every case we took with them, we were already just basically putting things in the record and could we get to the Ninth Circuit, please? Because we all know that's the only place we're going to get a hearing. But it's different now in Vegas, fortunately, knock on wood. We have better judges, and I think we get a fairer shot. But also, we don't get yelled at for denying charges, It is just part of the system. I think lawyers get confused about what it means to be nice in court, right? Like, I don't actually want to be, like you said. Feel free. I admire watching others, but I want to advocate for my client. And actually, I will be lenient I'm not going to object if the government, this happened recently in a case, asked for a bit more time to file their brief or to review something that we submitted. That's fine. No problem. I'm not here to be difficult, and I'm going to ask for the same thing in return in the future. But that's on just routine processing issues that we all need in court. But when it comes to litigating substantive issues, my job is to advocate for my client and not concede for my client. And the lawyer for ICE, their job is to do the same thing. I don't expect them to concede their position just to be nice to me. But nice should not mean throwing your client's rights away.
Right. And Matthew's right in that they have lots of cases. It's also true that now with a lot of the newer cases being electronic and most of the I-213s and the evidence that ICE has also being electronic, that what you're talking about is a question of downloading a PDF, uploading it to the government portal, which is not terribly difficult to navigate. In the old days, and this is still true for a lot of cases that are paper-based, but, if they had to print it and postage it and put it in the mail for 60 different cases, I'm not saying that would be a reason to do the solid and admit and concede, but they would have a better argument that I'm just overwhelmed.
Right.
But nowadays it's are you really? Plus, I think if enough of us were to do this, there's no reason why they couldn't get in the habit of presenting the respondent with the I-213, like Matthew was saying, along with the NTA.
Yeah, which increasingly seems to be the practice, although not consistent. It's not everywhere. In Vegas, that's 90% of the time they seem to be uploading it with the NTA, but I've seen a recent case where it wasn't. But can I push back on something, actually, though? I get everything you're saying. I don't want to make busy work for another attorney, but I think this also, when we focus on we can't make the ICE trial attorney work too hard, I think we ought to remember, and maybe not just the three of us, but everybody in the system needs to remember it's the respondent who is there, who's having, their life threatened, right? Be threatened with being taken away from their family, their home. They may be detained. There's a whole psychology and culture in immigration court where the person who is most burdened is treated like something on a shelf. In our court, when people are detained and then ask for time to prepare their case, judges will say, well, he's detained at the expense of the government. It's the government that's burdened, by this person being locked up in a prison. And that's backward. And I do say, I mean, yes, it's even easier than before because we have, starting to have electronic filing. But let's be real. If the government wants to forcibly remove someone from the United States, I don't feel that bad about making them use their photocopier.
Right.
Yeah. I always like it when they say they're detained at government expense. And I was like, you know what? You just let them go.
There's a remedy to that.
Yeah.
Yeah, exactly. Exactly. Like
Um,
there's easy cost savings here.
Well, and I don't want to make it sound like I'm super sympathetic because like the lawyers aren't even the ones making the copies, right? It's like,
Right.
yeah. And I mean, it's also true that like, oh, I have 60 cases. Well, guess what? Like you belong to the agency that put all those people on your plate.
Yeah.
You also belong to the agency that could go through those and identify, well, 10 of these are solid cases. We're going to agree to those. 10 of these are, candidates for dismissal. And these 10
Right.
could be admin closed. And so you have the work that you gave yourself. That's not my problem. And you also have the tools to alleviate yourself of that work, and you don't use them. And that's also on you.
And there's some other things too. I would be all in favor of trying to streamline some issues in court and figure out, what do we actually have to argue about in court? Because I do believe in that, right? That court time should be where there's real disputes that have to be resolved. And so many of our master calendar hearings in immigration court could have been an email or a doodle, just to schedule something. I wish we could talk to opposing counsel more. Like people, at least in Las Vegas, it's actually very difficult. There's not even a permanent trial attorney assigned to a case on the DHS side until an individual hearing. But we often have a lot going on in our cases when they're still getting successive master calendar hearings, but it's a different attorney each time, and each one, some of them are not very familiar with the file. And we literally don't know who to talk to. We're told to email a duty attorney email that is not always answered. And that just means that every issue, no matter how small, has to be brought into court, even though I would love to use the court's time only for real substantive disputes.
Yeah, no, 100%.
Yeah, no, it is nice when, you can discuss it with a government attorney, because there are sometimes you can really knock stuff out. Early on, is this a case that can be dismissed? It's funny. I just thought of this one conversation I had with this government attorney before this asylum case. That was, I think, pretty much a slam dunk. It was a Chinese Christian case, and knowing the judge, it was going to be granted. And so I'm talking to the government attorney about it and trying to see if we can get some stipulations and all that. And she was just being very obstinate about the whole thing. And she said, well, you have to look at it from our side. And I'm like, well, don't you think we're both on the same side? She goes, oh, I'm on the side of justice.
Right.
And I said, well, so am I. So we're both on the same side. This is what we're striving for. And really, the government attorney's role shouldn't be a zero-sum game. It shouldn't necessarily be all that adversarial, because what we're most looking to do is to see, now we're talking about relief side, asylum. Like, if our client is eligible for asylum, the government should be the first one to say, hey, you know what? They've met their eligibility, they've met their burden, and they should be granted asylum. Of course, that doesn't happen that often, but this is a civil arena, but this is not civil court where it's a personal injury thing, where we're suing each other and we have to take diametrically opposed positions because of our clients. That's not the case at all, but very few government attorneys see it that way. But I think we should approach it that way when we're speaking to them, to help tell them, like, look, really, we're trying to get to what the person's eligible for or not eligible for, and try to work it that way. I think it gets a little bit more congenial. But being able to operate on the same ground at the beginning part, meaning that we make them uphold their burden, that we're not just rolling over and conceding, I think does set the stage for that. I mean, it might seem like a paradox, but I do think it sets the stage for later on.
For sure.
Just to make a quick point, we mentioned that there are situations where maybe you want to just move the ball along. I do think getting the I-213, like Matthew said, is important. There are cases where maybe a person's only relief is in immigration court, and getting proceedings dismissed, like winning on the issue of removability, means now they're just undocumented and they have zero options. And so there's a weird paradox with the whole immigration system where there can be cases where that's true. I don't know that that's the majority of cases. It's certainly not the majority, but it can happen, and which is why, there needs to be a nuanced analysis. But I think for too many of us, the default has been switched to this thing that's too conciliatory, makes it honestly the easiest law job in the history of law jobs, an ICE attorney, even easier for some reason. So,
well, I do think now that we have video court, where I think most of the country, respondents aren't even required to appear in court if they're represented. Because I know one issue was when we actually had to go to court with the client, they have to take a day off. So sometimes you would deny charges and the judge is like, okay, we'll see you back here in like 2 months.
yeah.
Right.
Now the client is there and they're like, I have to take another day off from work. I live 5 hours away. I have to pay someone $200 to like drive me to court. And that can be a real burden. And that's something that would have to go into the calculus. But now, I mean, I'm doing court from my office on my computer and the client is working, which is great. They're not.
Matthew doesn't want to have pants on.
No, I don't have pants on when I go to court either. So this is not a change.
Okay.
We're learning a lot. Can I tell you a little story? I mean, this has bothered me for a long time, although my practice and what we do in our clinic has evolved. So we now, by default, deny charges unless there's a good reason not to. But it wasn't always that way. Even 5 years ago, we were more half and half. We've definitely been moving in this direction. But I think a lot of us were just trained in, well, this is what you do. And when I was a law student, so this is, back in 1999, I was a clinic student at the University of Michigan. And we were working on a very, very difficult asylum case. And I went in with my supervisor at immigration court. I was very nervous. It was my first time in court. I didn't have much training on exactly what to do. And my supervisor just whispered to me that, okay, when they're going to ask you to plead and you're just going to say admit, concede, and decline, decline to designate the country, right? That's the phrase, admit, concede, and decline. And I did, I was a good student, right? I did what I was told. And then I realized that right after that, the immigration judge said, okay, I find you removable. And walking out, I just felt, what did I just do? Everything we knew about my client was she was terrified of going back to her country. And all I had done was admit and concede. Why did I do that? And the thing is that there was no conversation with our client about it. It was just, my supervisor was just reflecting, that's just how it's done, right? And it was the default. So I totally agree with the idea of, one, if there's a concrete strategic reason why you actually don't want to defeat these charges, by all means, admit and concede them. Or if there's a timeline issue, right, talk to your client about it, right? It's their time. It's their life. Their time either taking off work or their time in detention that it might take, and go through, here's the advantages and disadvantages. It's totally their decision. But the problem when it's become this default is that I'm not actually very confident that most attorneys are even having that conversation. It's just the way it's done. And that's what's got to change.
Yeah, I think in this case with my colleague, ICE was basically accusing them of like, hey, what are you trying to pull? Like trying to pull a fast one. That ICE is somehow hurt by this. But at the same time, ICE is pursuing a prosecutorial discretion strategy of broadly using their discretion to dismiss cases, which would put respondents in the same position. So there's no reason to think that they have some sort of righteous position on somebody in proceedings being out of proceedings, if that's also how they've chosen to exercise the discretion at their disposal, like to take people in proceedings and just send them home. So I don't know. The whole thing is
one of my favorite things in court is when you see all these attorneys who just admit and concede, and they'll be very conciliatory to the judge, to the government. And then the part of the pleadings where the judge will say, do you wish to designate a country of removal? Like, if they're going to send you out of the country, where are you going to go? And then the attorney gets emboldened and they sit up and they say, Your Honor, we respectfully decline. The only pushback ever. And I'm not even sure why it matters. Why they're from Mexico. If you're going to send them home, send them to Mexico. But, their chest fills up and we respectfully decline. And then the government's like, we designate Honduras. And that's it. So.
Yeah, but that's exactly right. I'm curious, actually, I have no idea how that's literally a court culture. There's no rule that explains why that developed. But that's the phrase I learned in law school, admit, concede, and decline. And why is it that it became okay to decline to designate the country, but yet you had to throw in the towel on the fact that you can send me to some country?
So my last master, I did that. And the judge says to the government attorney, says, well, what country should we designate? And then the government attorney's like, I'm having a problem with my computer. He's trying to find like the NTA. And the judge says, well, the NTA does say he's from India. And the government's like, oh, Judge, it's okay. You can tip off the government. That's fine. I don't mind.
Right.
And the judge got really mad at me. He's like, what do you mean tip off the government? I'm like, well, you can tell the government where he's from, apparently. So go ahead. Like, it is a farce, right? But it is a funny farce. So, I mean, I like Professor. How do you think that this can best be remedied in court with practitioners in the government? Like, I guess, what is your advice to students? When you talk about the subject of pleadings, what is your pitch?
My pitch starts long before we talk even about what a notice to appear is, which is what's the nature of this process. I tell them, we're called the UNLV Immigration Clinic, but at the first day of our pre-semester boot camp, I tell them that's not the right name for our clinic. I inherited that name, but our clients have already immigrated. We don't actually help anyone immigrate. You might in your practice, but we do very little, very rarely do we ever have anyone actually trying to enter the United States, on a visa or something like that. We do almost exclusively deportation defense, and our clients have already immigrated. I starting with that premise actually after many years ago. I spent a long time working with our local public defender's office, and we have a good public defender's office here in Las Vegas. And I love the lawyers who work there, partly because we know criminal justice system is terrible and has all kinds of only immigration lawyers can appreciate the criminal justice system. But I love scrappy defense attorneys, right? Who, they're standing up for someone who otherwise has no voice, but they're also, to them, it's just natural that you put the government through its paces because liberty depends on it, because there's a human being at stake here. And after spending a lot of time there, I realized, I'm not practicing immigration law. I'm a defense lawyer. So I actually tell our students we are a deportation defense firm, and we're going to approach this just with the same mentality as criminal defense, because it has a lot in common, right? It is the government has actually locked a lot of our clients up, and the government is trying to take away their physical liberty. That's just like criminal law. And so we're going to approach pleadings the same way. If I were practicing criminal law, I would not, forswear ever doing a plea bargain. That would not be in client's interest. Plea bargains probably gone too far to the opposite extreme from what we have in immigration court, but it serves a purpose, and it's often in criminal defendants' interests. But the point there is that you at least are getting something in return, right? At least ideally, it's not considered a shock in most criminal courts to plead not guilty at the beginning, right? And wait for the government to at least make an offer, as opposed to what's happening in immigration court, which is where it'd be equivalent of going into Las Vegas Justice Court, facing a charge for a felony and saying, I'm guilty, and then hoping the DA is now going to be nice to me, right? That's backwards. And so that's the mentality I tell students to think about. And generally, though, this is an opportunity because, not all my students go into immigration law, but they all will confront courts that have court cultures where there's a way of doing things that may or may not be in the interest of your clients, but that the lawyers have come to accept. And that if you violate it, you're not violating any written rule, but, people gasp. And I want students at the beginning of their career to be sensitive to that and realize when that might be occurring, because sometimes it's our job as lawyers to actually try to change that and realize actually that it's not my job to just go along and get along with the club.
Yeah. The more that we push back on this stuff, the better the government should, in theory, get at their job. I mentioned this case of my colleague who denied the allegation sort of as a routine thing. They get the I-213 and they find that there's multiple countries of origin alleged in the I-213. I think we assume too often that, well, the government kind of knows and the government kind of has the evidence and it must exist. And so that's why you would just sort of go through these motions. But a lot of times they don't. And I think too about, this is a slightly different issue, but like with the Pereira case, this whole idea that, hey, a notice to appear that doesn't have a time and a date is not a notice to appear. And so many of us, I'd never even considered that an issue. It was just whatever. And some brave lawyer or crazy lawyer, I don't know what, decided, I'm going to take this thing all the way to the Supreme Court and change the interpretation of the law. So the more we're willing to push the government to do better, the better it's going to be for our clients. And that's kind of the whole point. So
I love that you brought that up because, I would love the audio tape of when the first time a lawyer objected to the government's failure to state a time and place for a hearing on a form that they never stated on any other forms. And I'd love to know whether they got yelled at for that, because sometimes that's what it takes. But, anytime I might start getting some seed of doubt about whether, are we being too difficult on being nitpicky and trying to defend people, USCIS will, send a form back because they think we, had an ink smudge on it somewhere, right? The government is not cutting our clients many breaks. And the law is not really set up to be terribly fair or even aware of all the factors of their lives that a normal person probably would want to take into account. So I think we have little choice but to insist on all these things if we're going to defend people.
So this happens with one or two government attorneys. I'll deny the charges, and then the government attorney will look at me and say, so are you saying that your client's a U.S. citizen?
Yep, gotten that. I've gotten that. I've had that shouted at students. Are you making an assertion of U.S. citizenship? If you want a citizenship hearing, we'll have a citizenship hearing. Yeah, no, that's what we have to prep students for when you do this. Exactly, that to understand I'm not actually making any assertion at all right now at this stage. You're making the assertions. You're saying my client doesn't belong in this country. My client doesn't have to say anything at all yet. It's all on you. But the fact that that is treated with that kind of shock, I think, shows that something's become deeply, deeply perverted about this whole process.
Well, my advice to immigration attorneys who may be listening and who do not deny charges and they admit and concede is to just try it. Just run it out there. Your next time you have to plead, just say, we deny all charges. We do not concede removability. And if it's written pleadings, put it in writing.
Right.
And just see what happens. Just give it a shot. I think what you'll learn is it's really not that bad. It's going to be okay. It's really going to be okay. You'll learn a new skill. It actually makes you feel a little bit like a lawyer. So give it a shot.
Yeah, and read that I-213 form. And if it says that a 6-year-old girl is a laborer, point that out to the judge, right? Because it's always to your advantage to be raising doubts about the reliability of the government's information. And those things, we are Hondurans or Guatemalans, boys or girls. Of course, Ron DeSantis would be super offended, by some of the gender mistakes we've seen on I-213 forms. But they're riddled with mistakes or lack of clarity. And sometimes, if you read them carefully, there are Fourth Amendment issues buried in there somewhere. But you shouldn't, have just 15 seconds to spot them, right?
Yeah, and also, I know I've had this before. You get an I-213 that lists some criminal activity that's not your client. And because you could not have that document and wait to the individual hearing when the government's saying, well, Mr. Sir, isn't it true that you were arrested in Los Angeles, California in 1997 for raping a 4-year-old?
Yeah.
And they're like, what? And you're like, what? You're like, what? Everyone's like, what? And this happened to me.
Yeah.
It happened to me at the beginning of my career. The information was wrong. That really delayed proceedings. We were able to get through it. But yeah, that if I had the I-213 in that case, we would have cleared that up beforehand. So there's a lot of good stuff in there. No reason not to.
Yeah. Well, Professor Michael Kagan, University of Nevada, Las Vegas, we really appreciate your time, and hopefully you've inspired a few people out there to take this a little bit more seriously. And where can people follow you on the internet?
At Michael G. Kagan on Twitter, right? Elon Musk's favorite website.
Mm-hmm. All right, cool. And we'll definitely post a link to that law review article in the show notes. Thanks again for all your time.
Awesome. Thanks, guys.